The broadcast is now starting. All attendees are in listen-only mode.
Welcome to the October meeting of the BCS SPA. It's nice to see so many of you here. We've currently got 32 people attending, apart from Stephen and myself. Just before we begin, I'd just like to point out that next month is our annual general meeting where the members of your committee are up for re-election. At the moment, I don't actually have a presenter for that for the rest of that evening yet, but I'm working on it. If anybody's got suggestions or recommend somebody, please get in touch. Tonight, I'm very pleased that we have with us Dr. Stephen Castell, who's at pains to point out that he's not a lawyer, but he's an expert on legal matters affecting software. So I'm going to get straight out of your way and hand over to him.
Thank you, Imo, for that very short and sharp introduction. That's great. And you've got more of my background, I think, in the notice. Good evening, everybody. Welcome, fellow BCS members and whoever you are and wherever you come from, you're very welcome, ladies and gentlemen, professionals all. And I'm going to be talking this evening, as advertised, on software defects in the law as the overall topic. By way of actually dipping into a course I teach called Avoiding IT Disasters, the Expert Way, Avoiding IT Disasters, shortened to Aitd. Sounds a bit like a disease, but there we go. And as Imo said, I must make the disclaimer, I'm not a lawyer. This presentation mustn't be regarded as or construed as legal advice. For that, obviously, you will, of course, consult an appropriately qualified and regulated legal professional. So getting that disclaimer out of the way, and now there we go. So my Aitd course objectives really is to give the benefit of expert witness experience in identifying and avoiding, that's the point, IT disaster projects, or DISPROs, as I christen them for short, and hopefully assisting in achieving avoidance of failure of key IT systems procurement, development, implementation, and delivery, and hopefully thus also getting better legal contracting for them, professional quality assurance of them, and improved corporate investment in IT projects and contracts. So that's the overall objective and aspiration of the course I teach. And the course overview, well, my credentials for it is I've been now involved over more than 30 years as an advisor and consultant, but most importantly, an expert witness in hundreds of IT disputes, UK and international, probably on 4 different continents, including, for example, the longest and largest software and systems implementation contract litigation cases, I would say actually anywhere, but certainly to reach the English High Court and the Sydney Supreme Court in Australia. If anyone's interested, I can talk a bit about those very large cases specifically, but that's really sort of fireside chat rather than trying to teach some principles and learning points. The course content goes over 2 days, so it's quite an intensive course. And the first day, I'm not going to read all this out, but that's typically the content of it. And the first day is focused very much on a dispute case study, which I've written, which is quite a chunky one and tries to illustrate and cover all of the issues and circumstances of fact that one would meet in a complex software development contract dispute. And we go into that quite deeply and analyze it deeply on the first day. And then the second day, we try and draw out some learning points and that we've discovered in doing that. And we have an interactive workshop, which we're going to do a little bit this evening, hopefully, but not go through the case study. We don't have time to do that. And I usually end up with a clinic where people can do a private discussion of any specific IT systems contract or problems they have. Obviously, can't do that here tonight, but again, you have my email address, I think, or you can get it from Imo. And if there is any follow-on questions on a specific issue that you want to follow up with me privately, I'll be more than happy to hear from you. So the learning points that we try and give as takeaways are just to learn the software and systems procurement, development, and implementation disaster signals. What are the common technical issues that produce IT disputes and litigation, and how can I avoid them? Try and become skilled as an expert, as if you were an independent expert, looking at your own project or your team's project or your supplier's project, if you're on the customer side, in assessing and dealing with the issues as you go along, and try to recognize what are the early warning signs that things are going wrong or might be going wrong. If so, how do you deal with those problems as they arise? And understand in particular, therefore, contract monitoring, turnarounds, and dispute resolution techniques and processes. So how to grapple with these problems when the thing is starting to brew up to looking like a disaster project, a stalled project. How do you get to a turnaround situation? And what are the techniques for dispute resolution? Becoming alert in particular to the pitfalls and uncertainties of IT outsourcing and benchmarking. They're probably these were the issues I put together maybe about 10 years ago now that were some of the big issues of the time. There are probably some other ones we can now add, which I haven't updated the slide for. But IT outsourcing became very fashionable and very dominant in that period, probably 10 to 15 years ago. And it produced its own set of problems. And this idea of benchmarking, that can mean many different things in many different scenarios. And it's quite tricky. But anyway, I won't go into that in detail this evening. And finally, get tips from the trenches. Having been involved in so many different cases, across so many different sizes of cases, complexity, types of application, types of industries, different scenarios, just to see if there's some tips you can take away to achieve the best outcome, if despite everything else, despite trying to avoid a DISPRO, you do run into an ID dispute or legal action. What springs out from all of this is that there are problems that you regularly encounter, that indeed I've encountered in all the hundreds of cases I've analysed, in all 5 phases of software supply, whether it's selling software at the start when there's a salesman or team involved, once you made a sale or you think you've closed a sale, then drawing up a contract. So for the contracting phase, hopefully that all gets signed up, the ink starts going dry on the contract, and then it's over to the supplier to do the designing, the technical stuff, designing of the software, then the building and testing of the software, and then hopefully, if nothing does go wrong, finally installing and implementing software. So those are the major headline 5 phases of software supply. And I've seen problems in all of those 5 phases. I mean, the first 2 just involve, well, the first one just involves a salesman and a customer. The second one, ditto, but also lawyers. 3 and 4 really are down to the supplier. That's within the purview of the methodologies and team approach, project management approach of the supplier and developer of the software. But of course, there has to be very good coordination, particularly when you come to testing and acceptance testing with the customer. And finally, that leads into 5. You could get that sign off to install and implement. And I found there are problems that arise in all of those phases, not least because they often pop up and you only don't realize they're a problem until you get into a dispute at the end. The largest case that has ever actually got full trial and through and with a decision in the English High Court was actually for a problem that arose in the selling of the software. It was the B-Sky-B, was it Anderson Consulting back then? Case. I'm sorry if I've misremembered the other party, but it was all down to held to be a misrepresentation by the salesman about what this system was going to be capable of. And the judgment was made based on the misrepresentation at the selling phase, despite the fact that tens of millions of pounds had been spent and there were claims of hundreds of millions for a failed major CRM system for B-Sky-B, or Sky as it's now known. So you really can get problems in all of these phases, which may not seem like problems at the time, but can pop up and become critical when you get into a dispute. You may say, well, okay, IT disputes, why should I worry? Well, if you're a systems and software professional, you suddenly find yourself being immersed in a most unfamiliar forensic methodology, which lawyers and the legal system are quite happy with, but will be very strange to you and very demanding, and you get beaten up by lawyers every day to perform, to produce evidence, to produce notes, to give witness statements, all the time trying to do your normal job, and you don't generally get paid any extra for it. I come along, or whoever comes along as an expert witness, we get well paid for looking through the whole thing and coming up with our independent analysis and opinion as our main job on the project. We're not trying to hold down a job as well, doing something else. You may have several projects running, but it's not the same as being still trying to work as a software and system professional, but yet run and support and hopefully successfully defend your company, your project, your procurement, whatever it is, as a key part, as a key factual witness, as a key technical witness in a dispute. So that's why you should worry. If you can avoid all of that and never get into even a dispute, let alone litigation, then so much the better. And some of the features I found that are common to many such cases, which should be borne in mind, often the customer and supplier think that only light customization is involved. These are tailoring a particular package. At breakdown, there's a large proportion of software work in progress. That can be difficult to then get a fix on just how complete and fit for purpose the software as built at the time of breakdown the software is. Costs can run to hundreds of thousands of pounds with months or years to reach closure. There's often was a hidden agenda that caused the contract to be terminated, not actually to do with the project management or the software quality. It could be a change of strategy at the board level that suddenly makes that project not so relevant, and people then try and find a way to get out of it. But one of the fascinating things is that the overriding real reason is very much so that there's a loss of confidence, basically. And secondly, there's a lack of creative thinking or experience in breaking out of this escalating situation. Probably no great insight there, but what is fascinating is that legal contracts, in my experience, are not capable of making provision for a loss of confidence or trying to allow for creative thinking in breaking out of a dispute. It's very rare to find a legal contract that can put terms and conditions and provisions that will accommodate for those things happening. So that's another reason why the dispute goes rambling and escalating on, because there isn't within the contractual framework a way of dealing with it, of what is the real problem with the project. So how does a forensic expert come to perspective and an opinion on the issues that he's asked to look at? Because you find that there are interwoven technical and legal issues. They can be both arcane in a legal sense and in a technical sense, and complex. And therefore, they can prove costly and time-consuming to unravel. These are some of the clear things that emerge. How do we arrive at that expert opinion? I've developed something which I christen forensic systems analysis, and I'm sure other experts that do this, I know they do, take a similar view, but we have a particular formal set of techniques which I developed over the last 30 years called forensic systems analysis. They focus in particular on testing the software in dispute. No surprise there, because that's still how we build software. It's a good methodology for not just assessing disputes, projects that have fallen into dispute, but also I like to teach and try and teach that they can be used as what might be called a litigation-sensitive software quality assurance and project management audit method for construction and implementation projects before they stall or fail or sink into litigation. And the key to all of this is the concept of software quality, which is no more than, is it fit for purpose in a very precise technical sense, which is in turn no more than, does the delivered software, what does delivered mean when it's broken down, but anyway, does the software meet its stated requirements? So the key is testing software against its statement of requirements is the only practical and universally accepted method of judging the quality of software and whether or not it is fit for its intended purpose. That's always been the case, and it's still the case, and it's no more the case when you're looking at the evidence and data from a particular project to come to an opinion on behalf of the court, because that's what the independent expert actually does. He may be acting on one side or the other, but he's there to try and assist the court with an opinion on software quality. That's the critical issue. And as I've said, this critical focus is on testing the software against its statement of requirements. That often has different emphasis and different style and different nature, depending on the nature of the case in question. It's very case dependent on the circumstances, the application, the industry, the point at which the project broke down, etc., etc. One of the key things that the expert looks at is what I christened generically testing incident reports or software fault reports or JIRAs, whatever you call them, whatever system of repository you're using for tracking and managing bug fixing during systems testing, during development. And often there's a large volume of project documentation and a large volume of software testing records. And the expert has to say, well, what do they tell us about the state of the software? In particular, can they tell us whether the customer was entitled to terminate, or did he himself repudiate the contract by so doing? This is often the key legal issue. Was there a valid termination done, or did the customer actually misread the evidence from the case, or just had some other agenda and effectively repudiated the contract, came out of the contract for no really good reason? So the key task that I do and that my team does is something we call E-flat, the expert fault log analysis task. And this is because for the purposes of rejection of the software and termination of the contract, any alleged defect must be assessed using a strict test as to whether it was a material defect. And I can talk about the background of where the idea of a material defect, it goes back, as I understand it, right back to a 1969 case where Hyams versus Docker, or was it Docker versus Hyams, where Lord Docker was seeking to sell a boat to Harry Hyams, a man who built Centrepoint. And then one of the others, forgive me if I can't remember the exact details, but one or the other wanted to pull out of the contract, and he got a surveyor in to say the engine was no good. And the other guy took it to court, and the judge ruled that just because the engine was no good, that did not go to the heart of buying a boat, and it depended on how quickly you could fix the engine. So we reflect that in our software material defect. The protocol which I and my team evolved over 25 years ago now, and we've used religiously and quite routinely, and is accepted by the courts as a protocol for assessing whether a software defect is a material defect and entitled you to allege a material breach of contract, and therefore you're entitled to reject the software and terminate the contract, are these three things. They're ANDed together. They all have to be true. First of all, does that alleged software fault have a large consequential business effect? And secondly, is it impossible, or does it take a long time to fix? And thirdly, is it incapable of any practical workaround? And I can talk more about that if you want to later on. Clearly, number one is something for the customer to assess. Number two is really something for the supplier to assess. And number three, whether it's a practical workaround, is a bit of input from both. But when an expert comes along, he's entitled and must give his own opinion on all those three things, based on the evidence also from both the customer and the supplier. So what we do is we rerun acceptance tests with each of those test incident reports or bug fault, outstanding bug records, assessing it according each of them to the material defect. And then we draw up something called a Scott schedule. Again, this is something which construction litigation is very familiar with. It's a formalized way of putting in all the alleged defects and saying why they're defects, what is the contractual breach that they represent, what's the consequences, what's the damages. And there's usually a column for the independent expert's report, and I'm used to giving my analysis of that and then giving my opinion as to whether each one is a material defect. So we draw up a very full Scott schedule of software defects, which is a very valuable document for the court, and both sides contribute to it. And that often gets argued over in very great detail at trial, if it gets to trial. There's also the other side of it, which I'll go through very quickly, but again, you may want to talk about in more detail. The whole issue of against that, there's often the allegation from the supplier, well, there were contract variations, there was specification drift, you made constant changes to requirements, we had to do all this extra work, which made it more difficult to fix bugs because we were always trying to hit a moving target. And you know, the parties do need to understand the impact on project scope, timetable, and costs of doing all requested software changes. So yes, they do have an impact, but it's usually the obligation of the supplier to draw up a formal impact analysis if asked to do extra work. That doesn't always happen. That itself can be very problematic. And when in dispute, the expert is then asked, well, were there changes? What do you think? If so, by the way, you still have a quality target to reach. What was the quality of the additional software built? You still have that same standard to meet, even if it was extra to the original contract. And assuming all that's good, what financial remuneration do you think is a supplier entitled for providing? Because this is what we call it, could be on a quantum merit basis. It is entitled to a reasonable payment for the extra work he's done, which may be extra contractual in terms of the original contract. So that could be quite complex quantum or value analysis to put forward as an expert, but that's something an expert can get asked. And that then often results, all of that gets synthesized and scheduled in something called a Scott schedule of software extras. So very often when you get to a trial, you end up with a Scott schedule of software defects and deficiencies versus a Scott schedule on the counterclaim of software extras. It's not uncommon to have both of those, if you like, poised to fight each other with the legal and technical teams arranged behind them, and the expert giving his opinion on each for the benefit of the court. We also have something which is to do with metrics, and again, I could talk about this a lot, but I'll just give you a couple of quick examples, and that would more or less take me to the end of the presentation. What we call FORBAT, the Forensic Bug Analysis Task. This is quantitative metrical analysis, giving what I believe is an objective graphical presentation of the true bug find and fix performance of the software house. And it's very understandable because it uses pictures for non-technical clients, lawyers, and judges. And the two examples I've got here, and we can come back and talk of them in greater detail if anyone's interested. First of all is a work in progress, which shows the cumulative, this takes all of the bugs in a particular project, and this particular one was over 10,000 in the whole database of faults for a project that took over several years. And the V1 to V8, it was actually released in 8 different releases across all those days. These are days, along the x-axis are days from the start of the project. And up the y-axis, you graph the cumulative reported, in other words, logged faults, minus the cumulative resolved faults on any particular day. So it's a work in progress profile, and you can see there are some very interesting signatures, peaks and troughs in it. But overall, that's where the curved line comes in that's been drawn on it. There's a general wrapping up and falling away of any bugs were outstanding. And that can show you a very illuminating picture of the performance of the software development of a team, contract, or whatever. The work in progress graph. And then the second one, which we very often use, you obviously have to have quite a large data set of fault reports. So this is appropriate where it is a big complex, easily where it's a big complex software development project. But I have used it where we had a very slender data set, and I can give you a war story on that one later if you're interested, where indeed the previous slide did not show that. It showed something quite different, and it showed a project that was on the road to nowhere, frankly. Similarly with this one, the scatter diagram, which shows for each individual fault, the fix time, the time to fix, the time between opening and closing it. And you'll see there's a general grain on this particular project, it's the same one as graphed as covered in the previous graph, that shows that the thing is converging to a solution where you're getting, there may be more and more bugs coming in. That's not important. You expect bugs during system development. That's what it's for. You test to find the bugs and squeeze them out, squeeze out the pimples, as it were. And you've done that. This graph shows that this project was converging to a solution. In fact, the customer terminated just before version 8, claiming that it couldn't converge onto a stable solution. We ended up giving a contrary opinion to that, and the case settled eventually, based on the illumination from these graphs. There are 4 or 5 other techniques to do with performance, real-time locking, operability. Occasionally you get an allegation there's a fundamental design flaw. That's quite unusual, because design is not something that's normally open or even understandable to the customer. But occasionally you get that, and you may have to take up the drains and go right back to how was the software designed. And you may look at logical data models and all kinds of things that may lead you to suggest that there has been a basic error in the design. It's unusual, but it can be done. And again, the largest case we were involved with in the UK, we had to do that, take it all apart right back to the original design. Then there's the whole project management and delay allegations. In other industries, there are experts that do nothing but give opinion on project management and delay, particularly in the construction industry. And they have software packages of their own that analyze things to come up with an opinion on delay and who is to blame. Very tricky, because very often the causes of delay in a project are multifarious, and try to section out who is responsible for what at any point in time can be very tricky. But often the expert is asked to give opinion based on masses of project management records, like reports, emails. These days, millions, certainly tens of thousands of emails on a long project. Finally, there should be, in good methodology, updating the requirements every time it changes. Well, if it hasn't been done, often an expert say, well, what do you think the final requirements document would have looked like if it had been written? I've only ever had to do that once, and that was a huge job to do. And you're really writing a novel, because you're creating something that was never created on the project before. And yet lawyers were interested, because it was a critical issue, the amount of evolution of changes and the extras that the supplier was claiming they wanted to be paid for. All of that, I've said for some years now, will be available on my future website, forensicsystemsanalysis.com. I still haven't got around and found the time to create that site. I've got the domain, but I haven't created the site, so I'm sorry, but it's still a forthcoming attraction. One day, maybe, hopefully. So in the dispute case study, which we're not going to go into tonight, these are the kind of questions. I won't go through them, you can read them on the screen. These are the issues that the expert is asked to look at. Tell the court what exactly is a software defect? What is this material breach a material defect? Is it a question of numbers? Does it matter if there's 100 of them, 1,000 of them? Well, the basic message is no. You only need one material defect to give you good grounds for material breach of contract. It doesn't matter how many bugs have been solved and fixed, could be tens of thousands. It doesn't matter how many are outstanding. They could all be non-material defects. They could all be fixed with 2 or 3 days. But if you've just got one that meets that earlier protocol, then you have good grounds, I would say, for claiming material breach. But you have to go through certain legal processes and formulas first, of course, and these are some of the other issues. And as I say, the final thing is, how do you determine software quality and performance? You do an expert system inspection involving testing the software against its requirements and giving an opinion in the claimant's Scott schedule. The claimant, I'm assuming here, is a customer claiming against a supplier based on this schedule of defects. So what comes out of this? Well, I think what comes out of it are some red warning flares. If any of these things are absent, you're likely heading towards, or could be heading towards, a disaster project. They should all be in writing. Again, I'll go through them quickly. You can read them. You may have arguments about them. And we might get into arguments about agile and DevOps. And hang on a minute, nobody ever writes a statement of requirements. Well, be very afraid, because if you get into a dispute, if you've got nothing in writing, then how are you going to prove to the court that the thing you have built meets its requirements? If you're saying there never was a requirement, it just becomes an uncertain contract, and you're into all kinds of problems with that. Number 3 is one I'm particularly fond of: datum transfer and migration. It's astonishing how many even big contracts where lawyers have spent a lot of time drawing it up, but there's no mention of who's responsible for data transfer and migration. And it's often only when you migrate from an old system to a new one that you find that the old system had lots and lots of corrupted data in there. IBM used to produce a report yearly. I'm going back 40 years now, and even then they were saying corporate databases typically have between 30 and 40% corrupt data in. And you only discover that when you migrate to a new system. And then you get into the argument, well, was it your data or was it our new software? So there should be a part of the contract that deals with that. And it's almost you may have to write specific new software to do the transfer and migration. And that's a software project on its own. So you need a proper contractual specification of that project, and so on. And these other things, which I won't go through, but you can read. You may dispute some of these, but these are all very key, what I would call red warning flares. If you don't have these things in writing, either at the start or as you go along, and they're good quality, well written, and you can rely on them when you get into a dispute, you've got a good evidential base to either support your case or defend your case, defend your case or support it against attack from the other side. So just to sum up very quickly, the seeds of a dispute are sown in all 5 phases of a software supply. The way we do our job, forensic experts, the way I do mine, is using this set of techniques I call forensic systems analysis. That's how we arrive at an independent opinion on the technical issues. And as I say, it's very much centered on testing the software against its stated contractual requirements, because that's how the software should have been built. That's how the software developer can tell you whether his software is any good, because that's how he tells whether it's fit for purpose himself. So we just really are echoing the software development methodology that's been around for 50, 60, 70 years. You then come out of that with learning these red warning flares, which I then sketched out. The learning points should come from that. And I've got a few tips coming up of how to use experts to help best. Again, I won't spend time on these, but we can quickly go through them. First tip, blindingly obvious: try not to let the dispute escalate into a legal action in the first place. So obviously keep good relationships with the counterparty, whether you're the supplier and the customer, or the customer and the supplier. Warn your insurer early. Every good software house should have professional indemnity insurance or product insurance as well. Often insurers these days are very, very familiar with IT disputes, and they're able to help you even extricate yourself from it as a matter of advice, because they don't want to be dealing with a major insurance claim. You'd be surprised how knowledgeable insurers are now about IT disputes. Certain of them, anyway. I would say consider use of an independent expert in negotiation. Other industries, particularly construction, have a dispute board idea, or an engineer who's there all the time and can be called on from either side to make a ruling on disagreements, let's just call them, not disputes, differences of view about some problem that's come up as you go along, and both sides agree to be to respect what the dispute board or the engineer says and adjudicates, and you just get on with it then. Whether you end up grumbling about it, you don't, because it keeps the project going. And if it is headed towards legal action, there are various forms of ADRs, alternative dispute resolution options, which again, I would normally go and just explain a bit more, but I'm not going to this evening. Mediation, you've probably heard of these, arbitration, and this other one, expert determination, which I am going to say about in a moment, a little bit more about, because I think it's very underutilized in our industry. But here's the second tip. If you do get into any one of these dispute scenarios and an expert is appointed, then please, these are some of the tips. Appoint me or the expert as early as possible. Do let us discuss the case with counsel, that's the senior barrister, before the pleadings are settled. Get a team building exercise going. I have to be independent, but that's not to say I can't feed in a lot of good suggestions about how to present the case in an objective fashion in the best way, because a lot of us have got a lot of experience, often much more so than some of the lawyers involved. Avoid asking for really late amendments. Make sure, and it's the key one, that the client has secured a complete reinstallable system image, forensic image of the software. You have a duty to preserve all the evidence untainted, inviolate, and critically, that involves the key evidence, which is the software system itself. That has to be done at a very early point to secure for a reinstallable, rerunnable forensic system image. Allow the expert to respond fully to the judge's orders. This is more a tip for the lawyers involved. And avoid giving expert tightly reined instructions at odds with the independent primary duties of the court. I won't dwell on those. And let me just quickly say what expert, this other method of dispute resolution, expert determination. It's used a lot in other industries again, but I've only done a couple of these over the past 30 years, and I wish I was asked to do more, because they were very successful. You have to be able to have a clear set of clear and unambiguous questions to ask the expert. And the determination's done in an interesting role. It's a role of an expert and not in the role of an arbitrator legally. And the issues to be determined have to be well defined in a written expert determination agreement, which both parties say they will be bound by. So there's no argument about what the expert determines, there's no appeal, and there's very few grounds on which you can challenge an expert's determination. And good or bad, both sides agree this is a technical issue and we want an independent answer on it, and we are both going to be bound by it, whether we like it or not. And I think it's such a good idea. I'm rather surprised it's not used more often in IT disputes. But in my experience, maybe I'm just not seeing them. Maybe it's, in my experience, it isn't used nearly as well and as much as it ought to be. So that's really my wrap up for what I want to do, my dip into the kind of course I teach on avoiding IT disasters the expert way. And as I think I said, we may have sketched out in the intro to the call, in the call notice. Want to now throw it open to your issues and questions and any clarifications you want. And these are some of the points that kind of occur to me, and I think to Imo as well, as to what some of the questions that might be in your heads, but you may have a completely different set. I'm very open to hearing anything. I mean, I'll go the high risk route and say, ask me anything. If I can't answer it, then I can't answer it, but I'll do my damnedest. Maybe other people can come in and have a discussion.
Stephen, are you able to see the question panel? Because we've had a couple of questions raised already.
Okay, just a little tail ender, because it suddenly came up there over the last few days. I came across the fact, probably many of you know it already, that AI is now it's galloping ahead in all areas of life, and that's a discussion for another day. But none more so than in assisting with the software development project tasks. And here's a question: who are you going to sue when it's an AI bot that produces software that you may allege as a customer failed, or was defective, or caused you consequential damage? And indeed, how can you even identify which defect, or was there any defect, when you can't even discover whether there are requirements in compliance with which the AI bot presumably designed and constructed the code? If it's a kind of machine learning evolutionary bot that keeps to its own brain what exactly is the requirement that it's been building this software to. And even if you asked it or found a way of asking it, you may not understand the answer. So there's an interesting future about AI in software development. And there's a whole set of, I don't know if you can make a note or the slides can be available afterwards. There's a few links that I found, which just shows how vigorous this whole development now is. I won't dwell on them, but you can see this in the slide presentation if you want it later. And indeed, what came across my desk just today is a specific thing. Again, some of you may know more about this: robotic process automation, RPA. Panorama Consulting Group expected to reach 2.4 billion in 2022 alone. It's a type of automation technology, not machine learning. It's distinct from that. It's just simply bots automating certain processes in writing software. And there's predictions that it's going to be transformative for the development and production of software. And already organizations are deploying it, and some are doing it in place of ERP, enterprise resource planning systems. Panorama are very big in that, or using them in conjunction with ERP systems. And I'm just wondering whether the day's going to come sooner rather than later when I find myself up against a bot expert on the other side, independent expert. And would a bot have rights of writing an expert report for a court case? That's an interesting question. But anyway, those are my thoughts. But you would doubtless have your own. And I'll shut up at that point in saying what I want to say and deal with some of the questions. Are you going to moderate those and propose them, or do you want me to just try and go through them?
It's quickest if you read them yourself, I think, provided you have access to the questions panel.
I've got two little symbols here. One seems to be, here we go. No, it's not that one.
All right, I'll read out the questions.
It's questions, isn't it? That's what I'm looking at.
Questions.
Yeah.
We've got 4 now.
Have I? I can't seem to see all of them. Oh, it's a very small window. Can I increase the size of that window?
Let me read them back.
Yeah, okay. It's probably easier if you do because you're across them.
First question from Peter McIlwain John is, if we could send Stephen back about 20 years, what advice would he give to those involved in the design, development and delivery of the Post Office Horizon system?
Well, I can answer that in this way, quite specifically, in that I was actually approached to be expert in one of the first intended prosecutions. I'm not sure it was actually launched back in around 1999, exactly 20 years or more ago, for one of the first sub-postmistresses, I think it was a lady, by her lawyer, who said, hey, we've got this case where this lady, who's in tears most of the day, is being accused of fraudulently fixing the books in her little sub-post office. And the post office is claiming that it's their system's fine, and it must be her fraudulent use of it in some way that has caused the losses or the discrepancy in what she says was the takings in the shop. This is what it boiled down to, and what the accounts that the system was creating back at the ranch, i.e. back in the post office central, said should be what she taken, and there was a discrepancy. And I said, well, fine, that sounds like a perfectly standard piece of forensic IT stuff. This is my rates. I think I need to do at least a slender amount of what you told me, so many hours, days work. That's my budgetary quote. He went off and tried to get legal aid for me, which was pretty miserable then. It's even more miserable now in terms of rates. And I don't know whether he could, never mind about not getting any kind of budget, he just could not get legal aid for her. So I didn't get hired, and I really didn't think very much more about it. I thought it was one of these odd cases that pops up from time to time. And it wasn't until quite recently that suddenly one realized that there were hundreds of post office sub-postmistresses and sub-postmasters who were facing civil prosecutions. So what was the question again? What advice would I give to whom? Whom am I giving the advice to? Sorry, just remind me, Mo.
Well, it said, you know, if you're able to advise yourself 20 years before, out of today's
Advise myself. Yeah, well, I don't think I gave any more advice than I gave at the time, which is to do a diligent proposal with a budget, which didn't happen because this lady was legally aided. And it's, I think, the Horizon scenario, disaster, let's call it, for all kinds of reasons. People have, lawyers have described it one of the worst legal disasters in recent legal history in the UK. It rises, and it still arises because of the inadequacy of legal aid to defend. In this case, it was a civil prosecution, which itself is a kind of bizarre thing, where the post office, as I understand it, and again, I'm not a lawyer here, was kind of judge, jury, and prosecution in its own right. And because it had unlimited resources against an individual sub-postmaster, it could just go motoring on, bringing these civil prosecutions, rather than them going through a criminal prosecution route, which would have meant they would have had to go to the CPS, as it then was, a criminal prosecution service, who would do a test as to its viability. And they may have taken a more robust view as to whether these were cases that should have been brought on the evidence that was there. I have no doubt in my mind, I can't prove it because I never did it, that if I got the budget and if I'd been allowed to ask for disclosure and discovery, as it was called then, of the evidence of the system, and I had proper access to that PO Horizon system, I have no doubt in my mind that I would have found the bug, or I would have found evidence of the bug, which effectively was causing, it was an intermittent bug, difficult one to find because it's a runtime communications error bug of a system going down because of a communications error. Remember, back in 1999, we didn't have such a robust high-speed internet as we have now. And I'm not even sure they used the internet. They may have used fixed phone lines for it. But anyway, when you got a communications fault and the system then had to come back up again, the nub of the fault, as I understand it, was that it then didn't recreate. It didn't do a go back, a backwardation, if you like, to recover the accounts as they were at the point it failed. But somehow the dislocation got written into the accounts as a discrepancy between one set of records and another. And the post office chose to believe that it was the post office user, the sub-post mistress or master user, that could somehow cause that discrepancy. I mean, there's two issues there. One is to find that fault and reproduce it. And intermittent faults, particularly communication faults, are just difficult to identify and reproduce. But I've done it many times, and a good expert has got a nose for those sorts of things and will, if you get the budget and the time and the cooperation, of course, you have to have the cooperation. In this case, the post office, they're the ones with all the evidence, to be able to reproduce it and rerun a test that will reproduce it and show and reveal to the court, or indeed to the post office, that at least is a possibility. That as it's a prosecution, this is a weird thing. For a criminal prosecution, you have to prove something beyond a reasonable doubt. For a civil case, it's on balance of probabilities. I don't know what the test is for a civil prosecution, but there surely would have been, I'm pretty sure, confident in my own brain, I would have found enough to cast reasonable doubt on the only conclusion that the post office was coming to, that somehow or other it was post offices, postmistresses and sub-postmasters that were fraudulently somehow fixing the books. The second point is how are they going to fix the books simply as a user? The postulate is, but anyway, there we are. I don't know whether I have any more advice to offer me or anybody else at the time, except can we have better legal aid, please? But that's even more so today than it was back then.
Yes.
That plea.
Thank you. There's a couple of follow-up observations. One is from Peter Farley, who says that the odd thing in this case was that the dispute wasn't between the supplier and the client, it was between the client and their users, end users, or victims.
Yeah, exactly. That is odd, bizarre. I don't think I've ever come across that in any of my cases. Not only that, these were a user that were independents. They were the gig economy. I mean, they're not employed. I don't think they had an employee contract of employment.
That's the point, isn't it?
It's a special sort of contract to be a sub postmaster with the post office.
So in a way, Fujitsu were the supplier of the software, and the end users were the. Had to accept.
Yeah, we're the ones that they. So again, there's another bizarre element. Well, if these people were capable, if you had built a system that is capable of being defrauded by your users, question: aren't you as culpable as they are? Shouldn't this be one of the tests you should have done and foreseen? If there is some way that somebody can defraud the system, isn't that a test you should have done when you built it?
Surely.
For one of your users? I mean, the whole thing is weird. And obviously the other weird thing, and other people, I don't want to say anything libelous, but other people have already commented on this. The way that the more tragic thing and astonishing thing is the way, apparently, I understand, allegedly, the post office went on with these prosecutions even after it knew that it had this error in its system and this fault.
That's right.
Because it is suggested they didn't want to lose face. They wanted to double down and maintain their position on it.
Could well be.
But that's an allegation. I don't know how true that is.
Yeah, we need to bring discussion about Post Office Horizon to a close. Just one last observation from Peter is that the key insight in this post office case came from the logs of the technical support system. So there's an interesting source of information when you're compiling your evidence. You can look at the logs of what was done in technical support to sort out problems. Okay, let's go to the second question.
That's what I'm saying about presentation. That's what the expert looks at. That is the disclosure I would have sought. All the project records, all the fault reports, the whole history of the software as recorded. And this was, I know something about the team that did it. This was a very well documented project. A lot of money was spent on the production and the project management of it, none more so than on the very meticulous testing and recording of testing. So there's a huge amount of data and logs there of test results and fault log reports. That's the sort of disclosure. And part of the tragedy of the whole case is how subsequently, when other cases are brought, even when experts were involved, they couldn't get the judge to agree to disclosure of that. That's the bit I find astonishing, because I've never had that. If you're an experienced expert, you've got experienced IT lawyers, and you know how to couch and present a request for disclosure to a judge, and if necessary, call for a directions hearing where I've had to stand up in court and be cross-examining on why it is I'm asking for disclosure of certain evidence. And that's down to the experience and quality of the team. And that also astonishes me, that it is said that all the time the post office managed to avoid having to give disclosure of the only evidence there was, which they had. I mean, it's just unthinkable that a judge could not readily see that and be convinced to give an order that they must disclose all of that project documentation. I just do not understand that. I've never had that in any of my cases.
The next question was, have you ever backed away from acceptance testing because requirements are too poor?
Coming in as an expert witness, you have to make do with what you've got. So yes, you can try and do a rerun an acceptance test, but if the documentation of that, the definition of the requirement, therefore the test scripts and the test plan that you write from the requirements to test that's where the requirement and the deliverable meet up, and you write the thing based on the original requirements. Some of that is very poor and absent and poor quality and incomplete, and you have to do the best you can and write an opinion with the caveat that you you can only do it on what you got. So I've never backed away, because you're asked to give an opinion, but it may be an opinion that's heavily caveated, or just saying in these particular respects, I cannot give a firm view on this, and this, because it has been impossible to put that to an objective test. So it is a problem. But then if that's the case, then the other side of that coin is you're able to say under the project management and methodology, well, it's not very well done because they don't have how do they know that their software is any good if they can't even present data to an independent expert to come to his view? And one of an article I wrote for IT Now a couple of years back on the DevOps situation. I said at the end, how do you, as a DevOps manager, if the project were to be terminated tomorrow, how would you tell an independent, and I mean lawyers and experts in the court, how good or bad your software is? What do you do for judging its fitness for purpose? If you are going to say you're using agile methods and DevOps supply and project management, where the thing is constantly iterating. I mean, we can have a separate discussion about that. But in my view, DevOps and agile generically, it's fine if you've got an in-house team and everyone's in the same camp. But the instant you want to contract with somebody externally and have a certainty of contract, you need things in writing. And agile does things by managing time boxes and managing an input, not an output. You can only say what you've done in the time.
What you're doing is you're agreeing with the customer that you'll agree the requirements as you go along, and so what they're buying is a service and not a product. And so
yeah,
it's worked very well on the project I'm working on at the moment. So every little increment, you have a minimal requirement spec, which consists usually of a few wireframes that say this is what the mobile app will do next.
Yeah. Okay.
And because everybody's using the product the whole time, they know what it does. So the increment is obvious to everybody.
Yeah, I think there's something about incremental management there, increment management, which makes that work.
Mm-hmm.
And to the extent that you, as a good professional, maybe document those things well as you go along. So actually, that's fine if you end up with something that's well documented, but has evolved and grown as you go along. Then there's no problem with that. It's when you don't do those things, and my impression is that often doesn't get done as well as perhaps it should be done. So the increments and increments can be sudden and large, not the kind of, well, the word increment suggests, there's always this joke about quantum leap. A quantum leap is actually a very tiny leap, not a very large one. But we tend to use it colloquially as exactly the opposite. So yeah, well, what's interesting, I've yet to have a case where agile methodology has featured. I've not really had to face, because as I understand it, agile methodology, in my knowledge, is used much more within. Well, it's an in-house methodology for the supplier. He can do what he likes. He can, employ butterflies to write software if he wants to. All he has to do is deliver fit for the how he does it's up to him. Very rarely does a contract specify how you have to do things. Mm-hmm. You just have to deliver the deliverable, the fit for purpose software at the end. And as long as he does that and the customer's happy, actually what methodology is used in-house is up to him.
But it's very important like you say.
Yeah, it can work. I'm just saying I can see immediately if the plugs were suddenly pulled and you had to suddenly open up and reveal where you are, how do you do this test of material defect?
The theory is that because you're never more than sort of a week or two into work in progress, the client is at liberty to terminate the contract at any time, and they'll have working software. That's the point. And it's very interesting to hear you say that you've not been involved in any disputes of this kind where agile methods were involved. So I think
true. And it may be because they don't get disputes, which is great. Yeah, maybe that's we're both saying the same thing from different directions. Yeah, why not?
I'd like to go on to another couple of questions.
Sure.
Frank has got his hand up. Thank Finn. So we'll come to you next, Frank. But first, Verity Maton has given us a very interesting question, which is that you're giving all this good advice about things to do and things to avoid, but whose ultimate responsibility is it to make sure that these 8 red flag items are in place? You know, should developers basically be sticks in the mud, i.e. to resist doing anything until these things are in place and not being pushed for by others?
Yeah, that's a tricky one. This is a comment you get from so many people. I mean, we haven't really talked about testing, but I know somebody wanted to talk a lot about that. The commitment to do thorough testing is something people apparently now have to fight for, when it is the only way we know of actually building software. Testing goes along with it. There is nobody's. I mean, there've been formal methods and there've been system analysis packages tried that can write accurate code theoretically from the start, but they've all come to nothing. We end up by building a bit and testing a bit and checking whether what we built meets what the customer wanted. I mean, it's quite simple. Whether you do that in little incremental steps or you do it in some kind of a global big way, that's what you end up doing. So that is the test. So the kind of red flags I said just arise from that process. And again, saying if at any point in time you are terminated on, or you want to terminate, the court, the independent expert, is going to come along and look for those things. And if they're not there, then you can almost say, well, there was a disaster waiting to happen, because you do need all these things in place. Again, you may do them incrementally, but they do need to be documented. So I don't know who, in terms of responsibility, I mean, if you are a supplier and you have agreed to supply, to sell a service at a price or on a license fee or a combination or a bespoke contract for a fixed price or whatever, then yes, I would say it's your professionalism to make sure you know what you are doing and can prove you know what you are doing if it comes to a dispute. I mean, the customer is always right. Incidentally, the customer, there's a case way back that the courts established that the customer has an obligation to cooperate. I haven't dealt with that in this presentation, but it's very important. The customer cannot just sit back with a smug smile on its face and say, well, off you go, we'll accept it or we won't, and if we don't, then you're at fault. No, the customer, the reason there's a contract is because you both want to deliver this system. And the court said way back in a leading judgment about one of the few we have in this area, that no, there is a duty on the customer to cooperate to achieve the goal of the contract. So you can't, you know, when it comes to actually building and testing the software, that's something in the professional purview of the developer. And so it's up to you to try and get all that in place, keep it in place, keep the documentation records up to speed, know where you are in the fitness for purpose arc story. And if it suddenly gets plug pulled, be pretty confident you can show, maybe doing something. I had a case earlier this year that actually I can't mention because it was pre-action and it just settled. And we did exactly, we had I was employed on behalf by insurers actually on behalf of a software developer, leading one in the financial services area, and they had very good software documentation records. They used agile methods, but we did have very detailed Jira fault logs, and they had produced some very good project management where they were showing to the customer as they went along how they were resolving a big long list of things that the customer kept saying wasn't right, and they were diligently picking off each one of those and getting really to the end. And I was able to do, or get them to do actually, those 2 graphs. And it was astonishing how straight away you could see this was a good quality software house. They knew what they were doing. They were converging to a stable, fit for purpose solution. And they got terminated on just before, as often happens, they were about to deliver a perfectly good system. So you can do that. These are, you know, we're scientists as IT people. We can do this graphing and metrics and documentation, because that's what we do when we build software. So that's where the responsibility really must be, I think, on the software side. Getting what I think is hidden in that question is, I think what has been said, is what if you can't get the budget or the commitment from the customer to pay extra or to be at all interested in it. I mean, often the customer says, I don't see all these project management reports, I just want the software. You know, the customer himself may not be investing in his own IT. This is what's happened with the industry, because there's so much supply side to the industry now. The actual proficiency of teams within customers, even big customers, is quite poor, I think, now. I don't know whether anyone's got views on that. So people, CIOs in customers that can fight that same corner alongside and say to their board, look, we have to budget to make sure we've got all this data and allow the supplier to do his stuff properly. You're right, it's difficult to get the budgets for it, because everyone's trying to get everything out as quickly as possible at the lowest possible cost. But I think first of all, the responsibility has to be the software supplier, because you should be doing that anyway as part of building your software, it seems to me.
Thank you, Verity, for that very stimulating question. I'm going to jump a few now and ask Frank Thin to unmute himself and ask a question, because he's got his hand raised. Frank, are you able to unmute? I've unmuted you, Frank. Can you speak?
Thank you. Yes. Can you hear me now?
Yes.
I can hear you, Frank. Yeah.
Okay, good. That's fine. There was trouble with my audio. I had to use the phone in the end. Thanks for all that absolutely fascinating lecture. The observation which I've made, and of which I think you're aware, comes from a slightly different perspective. Not so much an issue between provider and consumer of a specific bespoke system or something like that, but because of the state in which we find the reliability of software products is in question. And you've commented that you think to a certain extent that we've lost the cause of building proper quality into software products. But I think there are some things which we can do. You see my sort of general suggestions that we desperately need regulation in this area. You do not build a bridge which is full of unsafe components. You do not administer medicines without having them very thoroughly tested. But at the moment, there's absolutely no protocol whatsoever for deciding whether software should be sold or not. And I think this is seriously wrong, and it needs to be fixed. But one of the problems here, it seems to me, is that unlike the cases which you cite, the consumer and the producer of the software are a number of arm's lengths apart from each other. That makes things quite difficult. Somebody commented that the reason why we've got bad software is the complacency of the consumers. They're just not, they just put up with it. And of course, so long as we have that arm's length arrangement, or many arm's length arrangement, that's likely to continue. But on the other hand, one could put pressure on the distributors of software. Well, no, I'll go back one stage. The first thing is that the license terms that appear with most software products are intrinsically unfair. The provider of the developer of the software, it says, we should not be held responsible for the correct working of this product or for any consequential losses if it doesn't work correctly. That's outrageous. It should not be tolerated. And that's going to be a bit of a problem.
Well,
but the consumer
under the terms of
sorry,
there's such a thing as unfair contracts legislation, in which it has been found in the past that software products with such unreasonable terms and conditions were found to be in breach, and therefore those conditions couldn't be held up.
Right, and I'd like to see a number of cases in which we try to strike down those unfair contract terms. Now, that's probably going to be quite an expensive arrangement, because the large-scale providers of software are going to put millions of pounds, dollars, or whatever into defending those terms. But I think they are indefensible, but it would be a costly thing to do. What we could do, perhaps, is start at the other end. If the consumer says to a distributor or a retailer, the person who actually sells the product to him, are you going to do anything about this? And if the distributor says no, then say, okay, we'll find another distributor. And you just pass the, just make sure that eventually you have a number of distributors who say, look, we're having so much trouble with this software that they are happy to fund a class action that would make it possible to uncover some of the dangerous things there. But one of the things you mentioned is talking about examining fault reports and things like that. Well, we don't even see them, let alone evaluate them.
Okay, thank you very much. That's a very interesting set of observations.
I think Frank, we shared an email about this, and I think my feeling on all of that is, I mean, I'm in agreement with you fundamentally, but I think the possibility of introducing, let's call it licensing and regulation of the production of software, is a horse that escaped from the stable back 70 years ago when there were about half a dozen software writers. Somebody might have thought of making it a licensed and regulated occupation. It's long since gone, and anybody can be a software writer, and anybody can produce a damn good bit of software. I mean, look at the way the gaming industry is now the largest entertainment industry in the world, and most of it has been written to start with by odd blokes writing some stuff they just quite like to write. And it's grown into this massive, and it's defining new ways of writing software and new ways of even humans interacting and new whole industries and commercial developments. But so that, I think that's gone, and trying to introduce regulation and standards. I mean, ISO does have standards that do apply to software, but honestly, I think of the hundreds of cases I've done, I don't think I've ever had to even been asked by a lawyer to say to what extent was anybody failing to meet an ISO standard. Because the basic truth is that a really smart team following all the methodologies with good quality software can still produce a faulty piece of software. Conversely, a clever guy working in his garage for 3 days without any of that can produce a most exquisitely beautiful piece of software that's perfect. So that's the problem. That's an issue with software writing. That's the basic truth. So that's not going to happen, I don't think. What can happen, and does happen, and I'm involved in one case right now, and we don't really have it in this country, is the idea of a class action, which I'm actually involved in one. I can't say too much about it because it's not yet been launched, but it's in the cryptocurrency area. And if we get it, not if we, the lawyers decide whether they're going to finally launch it, get it off the ground, it hopefully will become quite high profile. And at least it's a US case where you can do class actions. The problem is when they are when they're really big disasters for software. The Boeing 747 one is the one that springs to mind. 2 plane loads, 600 people dead because someone didn't design a fail-safe into a piece of software, or thought they were designing to the specification they were given very good software, and it was. But it just left the pilots out of it, and that was all set to go. I was certainly on a list of potential experts but they just settled. People realise, and I think this is what happens with these licenses. I mean, I think I said in my email to you, I think where the rot set in really, first of all, when the industry moved to more product orientation than bespoke software. That happened long ago now, but none more so than with the rise of Microsoft and all the packages that came along with Windows and its various. And then when Microsoft itself launched Windows 95, quite brazenly acknowledging that it launched it commercially, a commercially on-sale product with 15,000 known bugs in it. And everyone said, well, this is what I asked myself, are these material defects? Well, clearly they can't be, because the thing still works. And it didn't mean that people suddenly had a rash of legal claims against them. So yeah, there were 15,000 bugs, but maybe not a single one of them was a material defect. So we now segued quite easily, without anyone noticing, into a world where actually buggy software is perfectly commercially sound, as long as it's not a material defect. And that's the problem. And agile in a way, when you're launching products, we're quite used now to people launching a major new website, a major new app, Everyone hits it and it goes down and it fails, it crashes. And they think, oh yeah, sorry about that. We didn't realize there were these extra, and it's almost become what you expect now. Nobody cares because nobody is going to be hurt so badly that they want to bring a legal action, or there's loss of life or massive consequential damage from it. When there is massive consequential damage, and that's where the class action concept can come in. So you get a lot of little guys who are each individually moderately, usually financially, let's face it, impacted. You get them together and the law allows you to create a class action on behalf of hundreds, thousands of people. It was the same with the Volkswagen Dieselgate. I was approached and gave initial opinion on discovery from Volkswagen on behalf of one of the early lawyers that were trying to get a class action going. Well, it was a group litigation, they called it in English terminology. I gave a lot of advice at the start. Then another firm took it over and it grew. And in the end, that was settled again. It was settled quietly. They pay, you can take your Volkswagen back and get it fixed and you can get some financial compensation. So part of the problem in our industry, and I said this when we did the very first case, which was GC Marconi and London Fire Brigade, which still holds a record for the longest time in court. It was over a year in court. And eventually both sides stood up and said, we won't be here tomorrow. We spent more on litigation than the claims were. We were really hoping that it would go the full distance and get some really good judgments that establish some legal norms for the industry as a whole. What is a software defect? What is the entitlement to add extras? What is the money that, how do you assess what money should be paid? What are the duties of a software writer? This was long before the industry we now have, where we have so many apps that people use every day that go to the heart of their lives that they're living. I thought there might be questions just because it's such a hot news story, the whole, yet again, Facebook and WhatsApp going down on the one hand, and on the other hand, the fact that this report has been revealed in the Senate hearing, that Facebook knowingly go on doing things to reduce the self-esteem, particularly of young women and teenagers, encouraging content on Facebook that does exactly that, when their own report internally says this is something that is inadvisable and they shouldn't be doing. When you're in that sort of scenario, the world's most powerful social media is itself not keeping to its own professional standards, allegedly, apparently, then how the heck do you start? They're saying that it might really now be, the commentary I've seen from the US, this is literally in the last 24 hours, these are only commentators commentating, they think this might be the trigger that really does force the US government to start breaking up Facebook in the way they broke up Aitd back in the 60s and 70s. Frank, it's an issue which is very important, but I don't see the mechanism of trying to impose some kind of regulatory and standards framework on it now is going to actually have any bite, because the industry is just too big and people can develop software and make money from it. And the sort of people that might have the deep pockets that would fund a litigation are exactly the people that invest in new software companies and make a fortune when they go public. So you haven't the people with their own interests here that are problematic.
We're running out of time.
Sorry, that was a long answer to a short.
There's a couple of questions I'd like to cover off before we finally break up. One is a very quick one from Malcolm Kendall, which touches on the issue of legal aid. He says, have you ever been involved in any cases which were financed through crowdfunding?
Short answer is no, I haven't. I've been involved in 2 criminal cases where there was legal aid for the first one, and that was one of the first prosecutions under the then new Computer Misuse Act, which we successfully defended a young lady on the grounds that all she did was something she was entitled to do within her contract of employment, that is to play around with code and try out things. She was accused of launching false trades on a stockbroker system to launder some of the money from a guy she'd fallen in love with, who was one of the Brinksmats robberies. So it was quite a celebrated case. And weirdly, I was then asked to use the same expert report on his behalf when he was finally came back to England and gave himself up. He was on Castell crime then. This is before Spain was part of the European Union. And anyway, that's one of the few cases I've done criminally, and I did manage to convince the court that there was reasonable doubt. There was certainly reasonable doubt that she'd had any intention of creating a criminal act, and you have to have intent, mens rea, for criminal act. Second case, much more recently, this was a young man of Indian extraction who had a very solid family behind him, who said, look, we will fund his defence, we won't rely on legal aid. So for once I got a decent budget to do some proper digging. Would you believe I went along to the supplier, techie people. It's great talking to techie people, because techie people talk to techie people, they tell you everything. And it very quickly became clear that this thing where he'd been accused of swiping his own credit card in a duty-free shop in Heathrow and giving a refund back to his card, not to the, so they have a refund promise, so you can take your card, and if you don't, next time you come to the airport, you get a refund. And they did find certain money on a certain account of his. And he said he thought it was a system that was wrong, because he had to swipe it. When you swiped a card through without a PIN pad. He said that we were told to just put a blank card through, because if it didn't read the original card, you then had to type it in. So that's what I did. And that's his story. And I was able to discover by going and talking to the technical people who supplied the package and in this very large retailer using it, and they agreed with me that actually it was possible that it could be a genuine mistake. So all you have to show is that one scenario is possible to cast reasonable doubt on the one they were prosecuting him on. But then I did have time and energy and money. It wasn't a huge amount, but at least I had time to produce a good expert report. And unusually, I think it's very unusual in cases generally, the prosecution said, you know what, I got a call as I was driving to the court. It was only a one-day hearing, and I was due to be cross-examined down in West London court somewhere, Uxbridge was it, somewhere like that. And my lawyer said, you don't have to come, because we just heard from the prosecution's barrister that he totally accepts your report. Wow. And they just cross-examined their main witness, who just fell apart because he just agreed with everything in my report, because it was the truth. Which is, and often you just don't have the budget to find the truth. So crowdfunding is an interesting one. I don't know to what extent people are using it to. I mean, I think they are using it to fight criminal actions, but to what extent they're using it for based on software, I just don't know.
That leads nicely on to the next question, which was from Sushila Ramani. On balance, do suppliers or customers usually tend to win when these cases do go to litigation?
Wow, I don't know whether anyone's done any stats on that. My personal experience is it conforms with the old adage that good experts don't go to court. Of all the hundreds of cases I have produced reports for, I've actually had to go to court and give evidence in a full trial, a number of fingers on one hand. Wow. I've had to go to court for directions hearing and for getting disclosure, and I could tell some very interesting stories on that. But normally, I mean, I'm not trying to boast or anything, but Queen's Counsel normally look at my report and they say, well, there's only one word for it. It's compelling. Serve it. And when that happens, if you've got the budget and the time and you get the knowledge, often I try and find a team that if there's some specific techie stuff that you really need an expert in the really techie details, you try and get them involved as a team. You try and make a case for getting budget for that in your expert team. If you get all of that, then you can do a really good job. And I'm very used to the idea that you take my report, you read it from word one on page 1 down to word whatever it is on page 300, and you don't need to read anything else. Nobody could find another. That's the truth. Castell's found the truth, you know. And when that happens, you get settlement. So I don't know the stats on that, because in all my hundreds of cases, 95% of them more I've never gone to court for, and the large percentage of those have been satisfactorily settled, I'm usually told, to the satisfaction of my client. I mean, you could interpret it either way. Maybe I don't get told of the fact that they thought it was such a rubbish report, they'd better settle on terms that the other side found satisfactory. but I don't get told that very often. Maybe they're just being polite. But that's been my personal experience. So I don't know the stats on that. And I've acted for both sides all the way along the line. Sometimes for suppliers, sometimes for customers, sometimes as a single joint expert, where you are actually, if you like, acting in the middle and trying to give an independent report for both, just to the court on behalf of both parties. That's very tricky. Try not to do those, because you're bound to cheese somebody off. So there you go. And I've acted as an expert determiner, an arbitrator, and a mediator. And usually settlement happens. I mean, it happens more and more now because, I say, insurers get involved, and they're getting very smart about how to settle these cases, because they don't want to pay the whole thing to go and have to pay lots and lots of fees, only to have to pay up in the end. So they try and settle early.
And which leads us on to the last question, I think, which is, how did you get into this discipline? And do you come from an IT background?
And what was the second part? Sorry.
Whether you came from an IT or a developer background?
Yes. Well, I came from certainly an IT developer background. I've been a programmer myself, and then a project manager and consultant, and I ended up in Tusros in their original management consultancy when they were just starting that up, too many years ago now to mention. And then I was hired by one of the clients in a small merchant bank and was what effectively we call CIO now, but it's Manager Group Management Services. So I got into that, but the main reason was because I became a well-known leader in IT and the law. I actually co-founded a company called Infolex, which is actually the UK's first computer-assisted legal information retrieval service. It was formed just slightly after Lexis and Westlaw in the States, which are full text retrieval services. We had an indexed case summary system, which we dreamt up ourselves, myself and my partner Neil Maybury, who was a partner then in Coward Chance years ago, a solicitor. He still is a solicitor, a very good IP solicitor, still practicing. He and I dreamt this up, and we were one of the first business information providers to something called Castell View Data, as it was to start with, Post Office View Data became Castell Videotex System. And we launched that and sold it very successfully, eventually sold the company. So I had a very high profile in writing about IT and law issues. And actually through Neil, you want to know how I got into it. I got called by one lawyer out of the blue to do my very first case in the mid-80s for one Miss Hibbs, who had a newsletter on green issues back then, which she produced on a typewriter, and she wanted to go digital. She bought a Commodore PET, and then she thought, well, I can get a printer attached to this, and I can do all kinds of fancy stuff on my newsletter, like graphics and diagrams. And she had quite a decent local company come and install this printer and connect it up to her Commodore PET. And then when she tried to start and do smart stuff with it, it just produced rubbish on this, what was actually a Sprocket hold line printer, about $3.5 grand's worth back in the mid-80s. That was a lot of money. You could buy quite a big saloon car for that back then. Anyway, I got called in with a very limited budget, just ready to do an audit, just to write a report saying, yes, I saw this happen. I wasn't able to investigate why, what the software was. That was it. Now, my very first case went to court in, I think, Devizes County Court. These young lads who'd sold the printer turned up looking smart, like their mothers loved them in their suits, and very, very honest, and told the judge they'd sold many of these printers to many different people. They weren't responsible for integrating it, connecting it to the Commodore PET. They just sold the printer. And when you looked at the contract, that's exactly what it said. I gave my evidence and said, well, I haven't been able to determine why it's doing this, but it certainly is doing it, which is really not much of an expert report at all, but that's all I could do. And the lawyers were happy with that. We lost the case. And she had to pay them, their costs. I had to reduce my bill from the massive 500 quid I was going to charge her to about 250 or something, because she was an individual litigant. That was my first introduction to expert witness work. My very first case, we actually went to court and we lost. And then nothing happened. I got a call towards the end of the 80s from another firm of lawyers saying there's a guy in Jersey with a banking system that he's threatening to throw out on the street by the end of the week. can you get down there tomorrow? This is Monday. Can you fly over there and just see what this thing does and write a report? Say, put it through some tests, whatever you think you can do in a few days, because they're switching it off and they're alleging it's rubbish and they want all their money back. They're going to sue our supplier customer. So that was hardware and software for you know, a private banking system back in the late 80s. So I did that, produced a report. It was before action, heard nothing more. Literally 2 weeks before 6 years after that, and remember there's a statute of limitation of 6 years for suing, I suddenly got a call from these lawyers saying, oh, we just received a letter before action from the other people. We've heard nothing for 6 years. They're now definitely going to sue us because they realise the 6-year limit's coming up. Oh, by the way, you wouldn't happen to have another copy of your report because we've lost yours. So I thought, oh my goodness, this are the days when I used to have a typist type it up for my handwritten report and give me one carbon copy for me to keep. And I archived them in staples I had at home. I thought, I think I've got a copy out there. And I was astonished. I was able to go and find the box and put my hand on it. So I photocopied it because I had a photocopier, sent it off to them, and they were able to settle the case. I missed a trick there because I didn't think to charge them any more money from it, but that's my problem. So those are my first 2 cases. And then suddenly in 1991, through Neil Maybury, my partner, who'd met another lawyer at a cocktail party, I suddenly got a call about this GEC Marconi versus London Fire Brigade case, which was and still holds a record for being the longest IT software development in court. It was over a year. And then record for the longest cross-examination of an expert. It was one of my colleagues that did the actual exam. And he was in court for 6 weeks being cross-examined on defects. Can you hear me still?
There was a lot of noise back behind you.
Yeah, that suddenly all garbled. Anyway, so yes, that's how I got involved. It was, and a lot of us that have been doing it this long, maybe not quite as long as me, kind of have drifted into it in the same way. It comes about. I mean, there's much more an industry of expert work, but to be fair, when you start analysing that, by numbers of cases in the English courts, I would think 75 to 80% of cases that use experts are clinical and medical negligence cases. They're doctors' experts. Second after that are probably civil engineers in construction cases and forensic accountants. And then there's a few other professions, and actually IT experts are in the last percentile. I mean, it's a tiny number of cases compared with all the cases that use experts. So people say, oh, how do I get into the expert industry, the market? It's not that big an industry. The problem is you've got, unlike other industries, you can't really go out and stimulate people to get into dispute so you can create a market for your product, which is giving an expert opinion. You've really got to wait for things to go bad and get a call from a lawyer. You can raise your profile, you can write blogs, you can write papers. I do it endlessly. You can give presentations like this to hopefully interested audiences, and go to conferences, network like fury, and try and at least get your expertise in front of lawyers, because they're the ones that hire experts, and they have to get permission from the court as well, of course, to appoint experts, and so that's how I got started. And really since that early 1991, 92, the big case for GEC Marconi London Fire Brigade, I tended not necessarily going out to find them in any aggressive way. I tended to have sort of one really big case every about 3 years, with all kinds of sizes and types of cases popping up along the way. And although I never set out to have a career as an expert witness, just simply because of the volume, and some of these big cases, I've had teams of like 6 consultants working on the Air Tools versus EDS case, which is the largest software development case that there's ever been. It did get to court, but because of 9/11, they settled very quickly and it never went the full trial. We had about 6 consultants in my team at peak. And that took up most of the year 2001 to produce the report. You can be very many months and weeks working round the clock on these things. So although one likes to think, I started my consultancy as a management and financial consultant in IT, trying to give proactive, positive advice and project management on behalf of clients. Once I got into expert witness work, it has become the dominant thing I did and do still. That's the way I think a lot of people find it evolves, that do stick at it and get called again and again on these cases.
And if you're wanting to get your first foot on the first rung of the ladder, it's probably worth getting your CITP and CEng through the BCS.
Absolutely, yeah. I mean, the US is particularly good on wanting experts to have a really long ream of formal qualifications, and you often get they have the deposition idea there, where you get pre-examined on your report, and very often a lot of the examination can be, you know, what university did you go to? What did you do your thesis on? What professional bodies are you applying? What papers have you written? I mean, they go on and on about that before they even start talking about the case and your opinion. So they want to attack the expert first rather than the quality of the opinion you're giving. That doesn't happen so much in the UK. The basic truth is that anyone legally can declare themselves an expert. There's no, although there are two main bodies, the Expert Witness Institute and the British Academy of Experts, who are kind of the professional associations, you don't have to be a member of either of them. You don't even have to have a degree or a CITP or a CEng. You can simply say, no, I am the world's expert in diddly squat software, and if you want an opinion of it, I'm the guy to come to. If somebody decides to hire you, they can do so, and you can write a report according to the format that you're supposed to write it for the English courts, and you will be cross-examined on it. It's up to the person cross-examining you to decide whether he can trash your opinion. But you don't have to have any, there's no benchmark or qualification to be an expert. You don't have to have any formal training. That is the openness of the common law system. That really, there was one legendary case, I wasn't involved with it, but it's a story that other lawyers tell, where in a court where you can have a public gallery, it's a public forum, a court, an English court, normally, unless it's secret and they have to declare it in camera. So you can have a public gallery, and they were cross-examining an expert. I think it was some chemical thing. He was some chemical expert in chemistry, and he was kind of blundering through this tricky thing he was trying to explain. And he made some assertion, and somebody in the public gallery shouted, "Rubbish!" And the judge said, "Oh, just a moment. Sorry, who was it said rubbish?" This guy rather embarrassingly, gingerly stood up, and he said, "Could you please identify yourself and what your qualifications are? This is something in the public gallery." And he did so, and it turned out this was a professor of chemistry somewhere that happened to be strolling past the court and thought he'd go in and watch a case. And he heard this other expert in a field in which he actually had written some of the major papers. And he said this, I'm sorry, my lord, the expert being examined, I disagree with much of what he has said. And the judge, because it's his court, he can do what he likes, he says, well, what I will propose to do, please, is to come down here. I want to swear you in, and I will ask the counsel to cross-examine you on this particular question. And he appointed the court, just appointed this guy expert on the spot. So it just shows, I mean, as it happened, he did have professorial qualifications, but you could do that. It's possible. It's perfectly legally possible.
You could also be held in contempt if you shout in the middle of proceedings.
Well, that's true. You have to be careful. But in terms of getting started, I mean, I do try and keep a network of people that I know that have got maybe specialist things, particularly in software, because software is such a vast field now, both in terms of methodologies, tools, languages, applications, industries, particular techniques. It's vast. And when you get a case where clearly there are some tricky special things to do with the software or the way it was handled, then it's nice to be able to say, well, can I have this particular guy? Look at his CV. He's done a lot of these applications. So try and get involved with a team that's an expert team that under the direction of an experienced expert, and that will get you started and get your name known. And if you then want to do something on your own, then that's another way of getting into it. Get some experience working with another expert, where you're not necessarily going to write your own report and have to swear it and cross-examined on it yourself, but can do technical support work to another expert.
Thank you so much. We've overrun by 10 minutes, so I think we'll bring proceedings to a close. I'm very sorry to all the people whose questions we didn't get to, but I hope we've answered quite a few of them anyway. So thank
As I
you.
say, if anyone's got any follow-up queries, then I think you've got my email address, or if not, Im can give it. By all means, please email me, and I'll do my damnedest to.
That's very generous of you. Thank you. Okay. Thanks everybody for coming along. Thanks for sticking around until the last minute, and hope to see you next month at the AGM. If there's anybody who wishes to volunteer to serve on the BCS SPA committee,
Thank you.
I'd be very pleased to hear from you. We specifically, the member groups now need an inclusion officer responsible for matters of inclusion, diversity, and educational liaison. So that'd be interesting. Right. Thank you very much. I'm going to end this now and hope to see you soon.
Goodbye.